The United States is not a state party to the Rome Statute of the International Criminal Court, which founded the International Criminal Court in 2002 as a permanent international criminal court to bring to justice the perpetrators of the worst crimes known to humankind, war crimes, crimes against humanity, and genocide, when national courts are unable or unwilling to do so. As of January 2019, 123 states are members of the court. Other states that have not become parties to the Rome Statute include India, Indonesia, and China. On May 6, 2002, the United States, in a position shared with Israel and Sudan, having previously signed the Rome Statute, formally withdrew its signature and indicated that it did not intend to ratify the agreement. United States policy concerning the ICC has varied widely. The Clinton administration signed the Rome Statute in 2000, but did not submit it for Senate ratification. The George W. Bush administration, the U.S. administration at the time of the ICC's founding, stated that it would not join the ICC. The Obama administration subsequently re-established a working relationship with the court as an observer. Following years of negotiations aimed at establishing a permanent international tribunal to prosecute individuals accused of genocide and other serious international crimes, such as crimes against humanity, war crimes, and the recently defined crimes of aggression, the United Nations General Assembly convened a 5-week diplomatic conference in Rome in June 1998 to finalize and adopt a convention on the establishment of an international criminal court. On the 17th of July 1998, the Rome Statute was adopted by a vote of 120-7, with 21 countries abstaining. The 7 countries that voted against the treaty were Iraq, Israel, Libya, China, Qatar, Yemen, and the United States. U.S. President Bill Clinton originally signed the Rome Statute in 2000. Signature of a treaty provides a preliminary endorsement, but a treaty that is signed but not ratified is not legally binding. Signing does not create a binding legal obligation, but does demonstrate the state's intention to examine the treaty domestically and consider ratifying it, and it obliges the state to refrain from acts that would counter or undermine the treaty's objective and purpose. Clinton stated that he would not submit it to the Senate for advice and consent for ratification until the U.S. government had a chance to assess the functioning of the court. He nonetheless supported the proposed role of the ICC and its objectives. The United States should have the chance to observe and assess the functioning of the court over time, before choosing to become subject to its jurisdiction. Given these concerns, I will not, and do not recommend that my successor, submit the treaty to the Senate for advice and consent until our fundamental concerns are satisfied. Nonetheless, signature is the right action to take at this point. I believe that a properly constituted and structured international criminal court would make a profound contribution in deterring egregious human rights abuses worldwide, and that signature increases the chances for productive discussions with other governments to advance these goals in the months and years ahead. After the Rome Statute reached the requisite 60 ratifications in 2002, President George W. Bush's administration sent a note to the UN Secretary-General on May 6, 2002. The note informed the Secretary-General that the U.S. no longer intended to ratify the Rome Statute, and that it did not recognize any obligation toward the Rome Statute. In addition, the U.S. stated that its intention not to become a state party should be reflected in the UN Depositories List. This is because signatories have an obligation not to undermine the object and purpose of a treaty according to Article 18 of the Vienna Convention on the Law of Treaties, also sometimes referred to as the good faith obligations. According to American non-governmental organizations Coalition for the International Criminal Court, the U.S. could engage with the court by reactivating its signature to the Rome Statute by submitting a letter to the Secretary-General. A treaty becomes part of the municipal law of a nation only when the treaty has been ratified, accepted, or acceded to. In the U.S., the Constitution gives the President power to negotiate treaties under the Treaty Clause of Article 2. The President must then submit a treaty to the Senate for advice and consent for ratification. And the Senate must approve the treaty by a 2/3 majority before it can take effect. The Senate may submit amendments, reservations, or explanations to the President regarding the treaty. Once ratified, treaties are generally self-executing, at least from the perspective of other nations, as the ratifying state fully binds itself to the treaty as a matter of the public international law and of national honor and good faith. In the US, however,